Okay, good day everyone. This is me again, G. Mark D. Bukog from BS Criminology 3 Delta. Okay, let's continue our activity 8F. 8F. Okay. Number 4, that the act be committed with abuse of confidence or obvious ungratefulness. Number 5, that the crime be committed in the palace of the chief of executive or in his presence, or where public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. Number six, that the crime be committed in the night time or in an uninhabited place or by a band whenever such circumstances may facilitate the commission of the offense, whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. Number 7, that the crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. Number 8, that the crime be committed with the aid of armed men or person who ensure or afford impunity. Number 9, that the accused is a decidibus. A decidibus is one who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime embraced into the same title of this code. That the offender has been previously punished by an offense to which the law attached an equal or greater penalty for 2 or more crimes to which it's attached a lighter penalty. Number 11, that the crime be committed in consideration of a price, reward, or promise. Number 12, that the crime be committed by means of inundation, fire, poison, explosion, stranding of a vessel, or international damage thereto the derailment of locomotive, or by the use of any other artifice involving great waste and ruin. Number 13, that the act be committed with evidence, premeditation. Number 14, that the craft, fraud, or disguise be employed. Number 15, that advantage be taken of superior strength or means be employed to weaken the defense. Number 16, that the act be committed with treachery, ilibosha. There is treachery when the offender commits any of the crimes against the first person, employing means, methods, or forms in the execution thereof, which stand directly and especially to ensure its execution. Okay, continue. Without rest to himself arising from the defense which the offender's party might make. Number 17, that means be employed to or circumstances brought about which add ignominy to the natural effects of the act. Number 18, that the crime be committed after an unlawful entry. There is an unlawful entry when an entrance of crime, a wall, floor, rack, floor door, or window be broken. Number 19, that the crime be committed with the aid of persons under 18 years of age or by means of motor vehicles, motorcycles, watercraft, airships, or other similar means. Excuse me. Number 20, that the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. Aggravating circumstances definition: those circumstances which raise the penalty for a crime without exceeding the maximum applicable to that crime. Kinds: generic, generally applicable to all crimes. Specific, apply only to specific crimes. Ignominy, for chastity crimes. Tertiary, for persons crime. Number 3, qualifying. Those that change the nature of the crime. Evident premeditation becomes murder. Number 4, inherent, necessary, accompanies the commission of the crime. It is an element of the crime committed. Evident premeditation and thief estafa. And July 2011, Philippine Supreme Court decision on criminal law and procedure. Criminal law, qualifying circumstances. Tertiary, the Supreme Court affirmed that the findings of the trial that the qualifying circumstances of tertiary attended the commission of the crime. Milan's act of closing door facilitated the commission of the crime, allowing Karandang to wait in ambush. The suddenly gunshot when the police officers pushed the door open. Illustration: the intention of appellants and Karandang to prevent any change for the police officers to defend themselves. Tertiary is thus presents the case at bar as what is decisive for this qualifying circumstances is that the execution of the attacks made it possible for the victims to defend themselves or to retaliate people of the Philippines. Okay. Let's go to qualifying aggravating circumstances. Excuse me. Qualifying aggravating circumstances. Number 1, gives the proper and exclusive name, places, and author thereof in such situations such as to deserve no other penalty than that specifically prescribed by law. Number 2, cannot be offset by mitigating circumstances. Number 3, must be alleged in the information integral part of the offense. Generic aggravation circumstance increase penalty to the maximum without exceeding limit prescribed by law. May be compensated by mitigating circumstances. Need na to allege may be proved over the objection of the defense. Qualifying if not alleged will make it generic. Requisite. Letter A, the offender is a public officer. B, the commission of the crime would not have been possible without the powers, resources, and influence of the office he holds. A public officer is any person who by number 1, direct provision of the law, number 2, popular election, or 3, appointment by the competent authority shall take part in the performance of public function in the government of the Philippine Islands, or shall perform in said government or in any of its branches public duties as an employee, agent, or subordinate official or any rank or class. Essential: public officers use the influence, prestige, or ascendancy, which his office gives him as the means of by which he realized his purpose. A. Taking advantage of public position. Article 62 was also amended by the Republic Act 7659. The legal import of these amendments is that the subject circumstance was being made a qualifying or special aggravating that not be affect shall not be offset or compensated by the mitigating circumstances if not alleged in the information. However, but proven during the trial is only appreciated as a generic aggravating circumstances. Under Section 23, 1, when the under Section 23, 1A of Republic Act 7659, when the commission of this crime advantage was taken by the offender of his public position, the penalty to impose shall be its maximum regardless of the mitigating circumstances. B. That the crime be committed in contempt of or with insult to the public authorities. Requisites A. The offender knows that a public authority is present. B. The public authority is engaged in the exercise of his function. C. The public authority is not the victim of the crime. D. The public authority's presence did not prevent the criminal act. Examples of persons and authority: governor, mayor, barangay captain, councilors, government agent, chief of police. J. Secretary of Department of Interior and Local Government. Excuse me. Role not applicable when committed in the presence of a mere agent, subordinate public officer charged with maintenance of public order and protection and security of life and property. Excuse me. Example: Barrio Vice Lieutenant, Barrio Councilman, next page, that the act be committed, number 1, with insult or in disregard of the respect due to the offended party on account of his A. rank, B. age, C. sex, or circumstances. Rank, age, sex may be taken into account only in crime against person or honor. It cannot be invoked in crimes against property. Rank refers to a high social position or standing by which to determine one's pay and emoluments and any scale of comparison within a position. Age, the circumstance of lack of respect due to age, applies in case where the victim is of tender age as well as of old age. Age of the offended party. Sex refers to the female sex, not to the male sex. Requisites of disregard to rank, age, or sex. Crimes must be against victim's person or his honor. There is a deliberate intent to offend or insult the respect due to the victim's rank, age, or sex. The aggravating circumstance of disregard of sex and age not absorbing in tertiary. As tertiary refers to the matter of the commission of the crime, while the latter pertains to the relationship of the victim with the offended. Number 2, that it be committed in the dwelling of the offended party if the latter has not given provocation. Elements of the aggravating circumstances of dwelling: A. Crime occurred in the dwelling of the victim. B. No provocation on the part of the victim. The victim should be the owner, occupant, or lease of the house. However, in the people versus Balanci, 187 ECRA 566, it was held that the victim need not to be the owner or occupant of the dwelling where he was shot, since the stranger as an invited guest is sheltered by the same roof and protected by the same intimacy of life it affords. It may not be his house, but it is, even for the brief moment, home for him. Uh, while the while the aggravating circumstances cannot be considered and trespass to dwelling or robbery in an inhabited house, as is it included necessary in these crimes in Article 62, it can be considered any robbery with homicide, because this kind of robbery can be committed without the necessity or transgressing of the sanctity of the house. That the act committed with one, abuse of confidence, no, or two, abuse ungratefulness. Abuse of confidence is inherent in a malversation, two, qualified theft, c, estafa by conversion, d, misappropriation, e, qualified seduction. That the crime be committed in the palace of the chief executive or in his presence, or when public authorities are engaged in the discharge of their duties, or in a place dedicated or religious worship. Requirements of aggravating circumstances of public office. A, the crime occurred in a public office. B, public authorities are actually performing their public duties. A, polling precinct is a public office during election. J, place the commission of the felony. Paragraph 5, if it was committed in Malacanang Palace or charge, it is aggravating regardless of whether state or official function are being held. Requisites for aggravating circumstances for place of worship. A, the crime occurred in a place dedicated to the worship of God regardless of religion. B, offender must have decided to commit the crime when he entered the place of worship. A, that the crime be committed, 1, in at night time, or 2, in an uninhabited place, 3, by a band, whenever such circumstances may facilitate the commission of the offense. Nighttime and uninhabited place or by a band, aggravating when A, it is facilitated by the commission of the crime. B, especially sought for the offender to ensure the commission of the crime or for the purpose of impunity. C, when the offender took the advantage thereof for purpose of impunity. D, commission of the crime must have begun and accomplished at the night time. Impunity means to prevent the accused being recognized or to secure himself against detection or punishment, or to facilitate his escape more easily. Nighttime begins at the end of dusk and ending at dawn, from sunset to sunrise. Commission of the crime must begin and be accomplished in the nighttime when the place of the crime is illuminated by light. Nighttime is not aggravating. Absorbed by treachery, it must be shown that the offender deliberately sought the cover of darkness, and the offender purposely took the advantage of nighttime to facilitate the commission of offense, to ensure his immunity from capture, or otherwise to facilitate his gets away. An inhabited place, one where there are no houses at all, a place at considerable distance from town, where the houses are scattered at a great distance from each other. Requisites: the place facilitated the commission or omission of the crime. B, deliberately sought and not incidental to commission or omission of the crime. C. Taken advantage for the purpose of impunity. While there is no hard and fast rule on the matter, or a place where there are no people or houses within a distance of 200 meters or less is considered inhabited. B. Whenever more than 3 armed malefactors shall have act together in a commission of an offense, it shall be deemed to be committed by a band. Requisites facilitated by the commission of the crime. B. Deliberately sought. C. Taken advantage for the purpose of impunity. D. There must be 4 or more armed men. See Article 306, brigandage. The crime is the band itself. The mere purporting a band, even without the commission of the crime, is already a crime, so that band is not aggravating and brigandage, because the band itself is the way of commit brigandage. However, when brigandage is actually committed, band becomes aggravating. That a crime be committed on the occasion of inflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. Requisites committed when there is a calamity or misfortune. 1. Conflagration. 2. Shipwreck. 3. Epidemic. B. Offender took advantage of the state of confusion or chaotic condition from such an misfortune, that the crime be committed with the aid of 1 armed man or 2 persons who ensure or afford impunity. Requisites that the armed man or person took part in the commission of the crime directly or indirectly. B. That the accused availed himself or their aid or relied upon them when the crime was committed. If the accused relied on the presence of armed men, availing himself of the aid of the latter, his liability is aggravated. However, where it appeared that appellants were not merely present at the scene of the crime, but were in conspiracy with the assailant, shooting the victim and leaving the scene together after apparently accomplishing their purpose, clearly evincing conspiracy. The circumstances cannot be appreciated. That accused is recidivist, one who at the time at his trial for one crime shall have been previously convicted by final judgment of another crime embraced in the same title of the revised penal code. It is important that the conviction which same earlier such must refer to the crime committed earlier than the subsequent conviction. Example of the crimes embraced by the same title of the revised penal code: 1. Robbery and theft in Title 10. 2. Homicide and physical injuries in Title 8. And recidivism, the crimes committed should be felonies. Recidivism cannot be had if the crimes committed is a violation of special law. Pardon does not obliterate the facts that the accused was a recidivist, but amnesty extinguishes the penalty in its effects that the offender has been previously punished for an offense to which the law attaches an equal or greater penalty for two or more crimes to which it attaches a lighter penalty. Reiteration or habituality. It is essential that the offender is previously punished, that is, he has served sentence for forms of repetition. 1. Recidivism, generic. 2. Restoration or habituality, generic. 3. Multiple recidivism or habitual delinquency, extra extraordinary aggravating. 4. Quasi-recidivism, special aggravating. Distinction between recidivism and habitual delinquency and recidivism. 1. 2 conviction are enough. 2. The crimes are specified. It is enough that they embraced under the same title of the revised penal code. 3. There is no time limit between the first conviction and the subsequent conviction. Recidivism is prescriptible. Number 4. It is a generic aggravating circumstances which can be offense and ordinary mitigating circumstance. If not offset, it would be increase the penalty prescribed by the law for the crimes committed to its maximum period. Number 5, the circumstance need not to be alleged in the information. In habitual delinquency, 1, at least 3 convicted are required. Number 2, the crimes are limited and specified to A. Serious physical injuries, B. Less serious physical injuries, C. Robbery, D. Theft, E. Estafa or dwindling, and F. Falsification. 3. There is time limit or not more than 10 years between every conviction computed from the first conviction or release from punishment thereof to conviction computed from the conviction or release therefrom to the third conviction. 4. Habitual delinquency is a special aggravating circumstances, hence it cannot be offset by any mitigating circumstances from the penalty prescribed by law for the crime committed. Additional penalty shall be imposed depending upon whether is already the third conviction and the fourth and the fifth and so on. Number 5, the circumstances must be alleged in the information. Otherwise, the court cannot acquire jurisdiction to impose additional penalty. Habitual delinquency when a person would end a period of 10 years from the date of his release, last conviction, the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification is found guilty of any of the said crimes, time or think time of the offender. Okay, that's it. Our activity 8F. Activity 8F. Okay, sir. Thank you so much.